question to me. That is it a case that
for future, then it is not over when the notification at them, which is this, in this case, it came in 2018.
Manos,
If this relaxation is also
Manos, this is
for fresh recruitment, then it
this cannot be for the fresh recruitment number one. This is for those people only who are in service. So this does not have any application.
So why are we going time? This doesn't apply.
I am not on that aspect. My lords put a question to me. I am on slightly different part aspect. I am saying that even if central government had to exercise any power, it had to satisfy the first three preconditions. 23 two preconditions.
Just state-wise.
Statewide. State should have come. And there we have five.
But they have said state is Uttarakhand is correct.
My lords, then it could be for Uttarakhand.
Then they said KVN also.
My lords,
Kendriya Vidyalaya is everywhere.
Kendriya Vidyalaya, then for Kendriya Vidyalaya, but not for every state. Not for every state. Not an omnibus notification applicable to all states.
Secretary of NCT said only 40% vacancies available all over.
My lords, here is come on record that you have how much? 3.5 lakh. 3.5 lakh for 19,000 vacancies. That submission that you have, the states would have to satisfy, or the entity would have to satisfy that they do not have the educational institutions or they have a shortage of qualified teachers. There are guidelines that have been issued by MHRD on 8th of November 2010. My lords will find them at page.
Are we concerned here right now?
No, my lords are not concerned here. But what I am trying to submit is that 23.2 has a prerequisite requirement, a goalpost to be passed before the central government can exercise that power. And how that has to be done,
There must be some data, some objective.
there has to be, and they have prescribed what is it that you will give to central government for the central government to consider that. If I can just very briefly show that, page 59, and there is a kind of a tabular chart that the states will have to provide, which my lords will find at 64, in the same very convenience compilation, number 1. So MHRD is conscious about that. But it's the same convenience volume.
Yes. You were saying where the shortage of that, there is a provision.
Only where there is a shortage of
Which page?
Page 59. It's like an exigency of shortage of number of teachers available because there are no institutes, etc. You may only and only in that circumstance relax it. So, my lords, these are guidelines under 35(1) of the RTE for implementation of provisions of 23(2). Now, my lords, there is a full thing here, a tabular chart, how the applications would be made. Please turn to page number 63. My lords, format for seeking relaxation under 23(2). My lords have that at page 63. Take note of that.
But so what does the shortage mean?
The shortage would mean that a particular state does not have enough number of teachers who possess that qualification under 23(1).
Diploma.
Yes, a diploma, D-led qualification. If a state does not have maybe enough institutions that give that particular education, or colleges that provide that education, or overall it does not have as many number of teachers as there may be vacancies at that given point in time, the state can, in this particular prescribed format, approach the central government and ask for a relaxation of that minimum eligible standards. Now that will have to be done in that particular exigency, the precondition of 23(2) being met. In the present case, it is noticed by the High Court that against an advertisement of 19,000 odd vacancies, 3,50,000 candidates with DLED are available. So the question of diluting or applying 23(2) does not arise.
Okay, anything else?
My lords, just one small part that is left over, I'll just quickly wrap up.
What is that?
Yes, my lords, the three judgments of this, two of this Honorable Court and one of Bombay High Court, my lords are completely familiar. My lords have said that yes, the fact that B.Ed is not a higher education. My lords, the judgments are in my lords' communication. I would only request one thing.
They have also been referred by the Rajasthan High Court.
They have been referred by the Rajasthan High Court, but that Bombay full bench judgment, which happened upon a reference because there was a divergence of view, actually sets out a complete chart to show how DLED is a special education that we are accepting.
That submission is there.
Yes. Now, my lords, my submission is here that if we allow...
Now you can give us a short note.
I will give my short note. I'll put it out. My lords, there's just one very small thing left. I won't dilate. I'm not going to take my lords to the judgment since my lords say that that's not necessary. Now, my lords, just quickly coming to the next. Now, if this present situation is allowed, where B.Ed stated to be higher education, which it is not, then what happens is that it will be a violation of 23. Because then the teachers who do not have that qualification set up by the academic authority will be allowed to give education to children, and it's an admitted position. Coupled with the fact that if you say do a bridge course in 2 years, you admit that they do not have the qualification. Now I come to the last limb of my submission, which is
All this, the Rajasthan High Court actually has not followed. Right? Yes. Rajasthan High Court has only taken a view that whether you have powers under 23(1), this, that's all. What kind of a course is what was the purpose
the pedagogical study.
What was the purpose of Right Education Act? What meaningful education? Is it the right? Whether the focus has to be to give appointment or to just have to give quality education?
I get you.
All that has not been done.
That was there before the High Court. Those all issues were framed. These were the questions which were framed, though not right, not answered. That is fine. But issues were raised.
My lords, those were argued, and I will show it from that page. My lords,
No point if you are argued and not recorded, then you have to go back to Rajasthan.
no, my lords, I have succeeded. I let us go back because my lords have held that if I succeeded on one point, I don't have to
Let us
go back on that. Now, my lords, I'm just quickly coming to the last limb of my argument, and that is bridge course, which is now prescribed by them to say, they're saying do a bridge course.
Not framed till date.
Which is not being framed, of course, till date. There is no bridge course. It was admitted yesterday. And zone of consideration versus eligibility. Eligibility is in 23(1), prescribed by the academic authority. What is sought to be done under 23(2) today, which is not done under 23(2), but even if I say under 23(1), is an expansion of a zone of consideration, of enhancing the number of eligible persons by treating the B.Ed to be eligible. My lords, even if something like this had to be done, I asked myself the very first test what it would be. Even if the zone of consideration or the eligibility is to be relaxed, it cannot be done ex post facto to say that you will be eligible, but you can acquire a qualification later on, which qualification till today has not seen the light of the day because there is no bridge course as the day. At best, if there was already a bridge course and a B.Ed candidate had done that particular bridge course and acquired that pedagogical qualification under that bridge course, they could have been eligible and the zone of consideration could have been enlarged. But for it to be put that you are already in the zone of consideration, you participate in the examination and you qualification later on.
That's it.
That is basically
Only 5 minutes. The launches have put us a query that if the NCT, only 5 minutes to add to this, the launches have put us a query if the NCT would have done this, then whether it would have been justified. Now, Maharaj, in that sense, we have raised this an issue when the petition was filed, the NCT notification was challenged and is being dealt with in reference to Article 21A. The right to quality education read with Article 14 and 16 in reference to public employment. Now, Maharaj, the stakeholders involved under the NCT Act is the central government. The states being the representatives, the experts being there. There is a mechanism provided for deliberations and discussions thereafter. So, what I'm submitting is,
Mr. Simple, yes.
what I'm submitting is that the child
have this going on.
Item number 28.11 and 28.1.
You are Rajasthan.
No, I am from the candidates belongs from the Bihar and UP.
The first we have Bengal. Let's have Bengal.
Kamala, I will be very concise before your lordships in making my submissions because broadly or minutely, all of the points are being covered of ours.
What is left?
Now, the latency your lordships will find. While power was exercised by the NCT under Section 23 of the RTE Act, well, they have not taken into consideration.
This is a challenge to a separate interim order. After a year, let's hear it.
Your lordship may conclude Rajasthan and then hear it.
Just a minute.
They have not considered.
Rajasthan is concluded.
Interim order has been have followed in Totodar.
But interim order says
It has followed Ram Charan Maurya. It has followed Ram Charan Maurya.
Yes.
Not right. That's another matter. This is 28.13.
So I'm sorry, I missed it up. Ram Charan Maurya has a specific paragraph that notes that there was no challenge to the notification.
Kindly give that in the note.
I will put that down, but I want to point
We know that there is no
there
challenge.
is a specific noting in the judgment that there was no challenge.
Yes.
Now, your lordships, if your lordships kindly come to the SLP petition 28.13, that one, page 107. What is the situation prevailing in the state of West Bengal? I have stated throughout in the petition, paragraph 38 and 39.
28.13 is Bengal.
SLP number 22923. 22923 of 2022.
We are actually opposing him, but we have no copy of his petition and we are not appearing. I don't know who is appearing.
Look, the Board of Primary Education there, this is factual, and how it affects both.
As notice issued and some.
Yes. Okay. Now, just kindly consider paragraph 38 and 39 and just read out your lawsuit. It is pertinent to point out at present that in the state of West Bengal, there are 619 primary schools. 690, and out of 619 primary schools, only 33 primary schools are comprising of classes 1 to 5 and the rest are comprising from classes 1 to 4. In West Bengal, the primary or elementary education comprises from class 1 to 4, not 5, rather than the state of West Bengal throughout the country. Now, in West Bengal, primary education consists of classes 1 to 4, upper primary education consists of classes 5 to 8, secondary education consists of classes 9 and 10, and higher secondary education consists of 11 and 12. Then you will see paragraph 39. The petitioner states that as per the information collected by the petitioners, there are 642 primary teacher institutions having the total intake of 45,350 students for the session 29-21. You must pause here for a moment. This situation has come up when the DLED was introduced. Diploma in Elementary Education as a specialized training qualification was introduced.
According to you, there are more teacher schools than normal schools.
Normal, there are. Then your lordships, approximately 250,000 number of DLED candidates.
Shall I proceed that additional point is in West Bengal there is no shortage of
DLED candidates. If this is so, your lordships, why the central government but they are passing direction upon the NCT to pass a notification under Section 23 objectives of the states, the different states were not considered. They were considered only the APS schools across them.
We shall consider that.
That's your lordship. Therefore, the exercise of power was not proper. This is against the objectives of the scheme of both the acts. Therefore, your lordship, the next your lordships will find page 137. But 137, I'm telling you, lordship, we added the notification also. But the approach was made basically by the Kendriya Vidyalayas to the central government and then NCT. Now kindly see, the Kendriya Vidyalaya IIT Kharagpur in 21-22 has notification for recruitment of teachers dividing B.Ed candidates specifically. Kindly, this is the state prevailing in the state. They divide the B.Ed candidates and say this is only confined to the only DLED candidates. This is very material. Kindly look at your lordship's notification.
We won't go into that detail.
I tell you lordship why this is necessary. Just for a moment. Because this shows that DLED candidates were sufficient.
That's what I'm saying.
Therefore, the approach.
The other statistics you gave, we are satisfied that they are sufficient.
Therefore, what the next?
That's all.
Any other point on that? Because the interpretation of an interplay of these two acts have been argued threadbare.
That's it. That's the only thing I'm saying, your lordship.
You have anything to supplement?
That's the only one thing to add. But whenever the power to determine qualification for appointment has been vested with the specialized academic authority, this is interlinked with the training qualification. Our collective losses. Now, one will be determination of recruitment for a primary teacher. When the qualification is determined, one has to assess what would be the qualifications. Here, DLED.
That's 23 one.
23 one.
And that
These are all that I'm trying to say. These are interlinked. The qualification and the training qualification. Determination of qualification for appointment and the training qualification.
training
This is a specialized qualification. I tell you, losses why section 12 is the power to determine and to regulate and fix up the norms for training qualification.
Yes.
And 12A for determination for qualification for appointment of teachers.
Okay.
Yeah.
On this you give us a short note.
And this is one thing. And other thing I tell you, losses, if persons have been brought within the zone of consideration, knowing well that he is on the date of notification is not eligible. That's why the rider, that 6 months bridge course, but it could have been otherwise. That there is already a course, a B.Ed qualified candidates have been made eligible to do bridge course, then come at par with the other qualifications DLED, and you may be considered for selections. This was not done. If this was not done, under what provisions of law the notification can be issued? Can it be issued under section 23? I'm putting a question to myself. When they doesn't have the minimum qualification, this notification is being issued with the intent to make them qualified. Isn't correct, your losses?
We don't know.
Otherwise, the 6 months bridge course, then the notification first ought to have come up. If there are insufficient DLED candidates, please, those who are B.Ed qualified, you can undergo 6 months bridge course, make yourself qualified, and then apply. This is not the situation, Malab. Because bridge course was thought of in 2010-2011. Even then, Malab, there was no bridge course. Nobody has pointed out your losses. Am I clear to your losses? First bridge course 2010-2011 for 2 years because there was shortage of teachers. But that bridge course was also not introduced by NCT. Now, even 2018 you were thinking of bridge course and making them eligible. This is therefore, Malab, this is a notification to make someone eligible who are not otherwise eligible. Very eligible. But this is entirely reversed both the provisions.
Okay. Yes.
Because I think fair and fair for the state of West Bengal.
And one more thing, just I point out. Now, the 20, they are still going on the recruitment. I pointed out at the time of the motion stage. Now, as of today, it's a fiction of law. As of today, 28 June 2018 notification is not in the book.
State.
It's a pan-India notification. It's not in the book. Because this has been passed by the High Court in exercise of the power under section 226(2). Your lordship has not granted any stay. So as of today, my lord, that notification is no longer valid unless your lordships interference
We will have to examine. Yes.
Weakness found as on in item 28.13. They are correspondent number 10, state of West
Who
Bengal.
are you supporting?
Our only request is this.
You are supporting BEd or which course?
It's totally in your lordship's hands, whatever your lordships decides. The state is only concerned with this, that pursuant to the 2018 notification, we conducted a recruitment drive and there are 16,500 teachers that are currently recruited. Because we have checked around 738 vacancies open because when this litigation started, we stopped the recruitment. But our request is your lordships may kindly, which whatever way your lordships takes a call, whether 2018 regime is upheld or 2010, may kindly not disturb this recruitment because otherwise, it will have
That will take into consideration.
yes, that's the only thing because otherwise it will have a disastrous effect on our infrastructure with regards to primary education.
So you are not taking BEd right now.
No, we had taken as per the 2018 notification.
Going back 2018 notification.
Yes, because it was the extant law when the recruitment took place, so we had to follow that, we had to comply with that. But we had to, our recruitment took place during the 2018 regime, because then now this Rajasthan judgment has come. Based on that, certain candidates went to Calcutta.
Don't want the added problem of primary education.
Yes, yes. Lordship anyway is aware of the problems with private board. Yes, Lordship, sir. The only request is, Lordship, can you disturb whatever the Lordship has? Yes,
as far as primary board is concerned, our stand is we are adopting the submission of the state. One. Second,
Kindly give a composite note.
item 20.
Only one line.
Item 20. And this is also we are appearing on the wait, sir.
I am appealing item number 28.11 and 28.12, my lord. I have sought submission, my lord.
28, you are for.
I am for the petitioner, my lord.
You are?
I am for the petitioner. I have filed a writ petition in both the
You
cases.
are delayed or?
For the delayed. I am
You
appealing
are
for the
supporting the
delayed.
delayed cause.
Yes, my lord.
Okay, so delayed cause has been extensively supported. Do you have anything to add?
Yes, my lord. One thing, my lord. What was the problem, my lord? In which condition the
Is there a shortage of?
yes, my lord. I'm just
Is there a shortage of delayed candidates in Bihar?
no, my lord. There is no shortage in Bihar, my lord. Neither in Uttar Pradesh, my lord. Well, I have filed the application for permission to file the additional document and in which the state government.
Who is for the state?
I am appealing for candidates of state of Punjab.
No. For
BSTC candidates.
for the
have not issued notice of
Notice has been served
directly.
notice has been served.
Yes, Lord. I have filed the application for permission to file the additional document in which I have filed the order of the Patna High Court in which the state government filed the counter affidavit and accepted that the more than 12 lakh real candidates are available for the primary.
Okay, we'll record your submission that they have.
And the same condition in the Uttar Pradesh also more than 5 lakh people.
You kindly give us a short.
And you are
Obliged.
I am appearing for the candidates of state of Punjab.
Yes.
So I have moved an interim application for intervener. Lordship, in state of Punjab, there is no concept of bridge post. In state of Punjab, every BEd candidates first have to clear the eligibility test. Only then they can undertake the ETT test, Your Lordship. Your Lordship, the situation in Punjab is slightly different, Your Lordship. Now, why I am seeking this clarification is because after this Rajasthan High Court judgment,
Then you wait.
state of Punjab,
I am appealing for
Sanction is used. Detach this.
I would submit your lordship takes a view on Rajasthan and then post other things later and see how it.
Punjab will detach.
Lordship, this intervention application only in Devesh Sharma case. Why I am seeking this clarification is because now state of Punjab has issued a notification after Rajasthan High Court judgment in which they have disqualified the BEd candidates. That petition is challenged before the High Court, but the High Court has stated that they will wait for the decision of my lord. Only then they will.
So
So there's no purpose now in looking.
Eligibility test, trial eligibility test is there.
This was challenged. Learned single judge struck down their inclusion. Matter goes to the division bench. The division bench approves the view of the single bench that they were not eligible to compete. However, the government makes a statement that we are proposing to make them also eligible. And therefore, the division bench says, kindly have now page 469, para 3, second para. This is what happens before the division bench. The government has expressed in the affidavit, this is a para 3, the extracted para. The government has expressed in the affidavit dated 19 January 2000, they would frame rules in accordance with the decision taken on 2nd June 99 in consultation with the Public Service Commission for future appointment of teacher training hands only in lower primary school and B.Ed and TTC hand in upper primary school as expeditiously as possible. This is a solemn undertaking which should be implemented with extreme swiftness. We do not want to keep the position uncertain and vague insofar as future appointments are concerned. It is made clear that we have validated the appointment already made for different reasons, etc. Then what the court division bench said was that the rank list published by Public Service Commission for appointment to the post of upper primary is valid. Direction given in the impugned judgment to rearrange the rank holders in so-and-so district and cancel the appointment of B.Ed holder is set aside. So what happened? Before the division bench, the government said we are going to amend the rules and make them also eligible. Division bench accepted it, said for lower primary you appoint as per single judge, upper primary they held up the process. That was then challenged by the diploma holders before this court. Your Lordship may kindly have now para 6 of the reported judgment. At page 470. Learned counsel, para 6. Learned counsel appearing for the appellant contends that when the terms of the advertisement quoted above are very clear to indicate that B.Ed degree is not the prescribed qualification, such candidates were clearly ineligible to compete and they could not have been allowed to take part in the selection test and be included in the select list. Learned counsel has relied upon so-and-so 2 judgments, etc. I need not refer to it. Then para 7. Learned counsel appearing for the state of Kerala and the Public Service Commission. Some of the private respondents have strongly urged that B.Ed is a higher qualification than TTC, and as in the process of recruitment of primary teachers in government schools, candidates with B.Ed were allowed to compete. The division bench was right in not upsetting the select list, etc. Then, my lord, para 8, state of Kerala Learned Council pointed out that pursuant to the directions of the division bench, Kerala education rules framed under the Kerala Education Act of 1958 have been amended for upper primary teachers. Now, along with TTC, B.Ed of recognized universities of Kerala has been prescribed as a qualification with effect from the date of notification. So, in Kerala also, from 2000, they made B.Ed as a prescribed qualification. Now, para 9 and 10 are very crucial, which answer the question before your lordships. Para 9. It is not disputed before us by the parties that the Kerala Education Act of 1958 and the Kerala Education Rule framed thereunder regulates recruitment to the post of teachers in private schools aided by the government. It is not brought to our notice that correspondingly the government memorandum or order which regulated recruitment to government primary school has been amended to prescribe B.Ed and equivalent degree as eligibility qualification for the post. So your lordships find that there is no amendment in the rules so far to include B.Ed. Now then what your lordship says? Your lordship says, I'll read it and then I'll comment. We find absolutely no force in the argument advanced by the respondent that B.Ed qualification is a higher qualification than TTC and therefore the B.Ed candidate should be held to be eligible to compete for the post. On behalf of the appellant, it is pointed out before us that trained teacher certificate is given to teachers specifically trained to teach small children in primary classes, whereas for B.Ed degree, the training imparted is to students of classes above primary. B.Ed degree holders, therefore, cannot necessarily be held to be holding qualification suitable for appointment as teachers in the primary schools. Now, this was the argument. And now, see the response. Whether for a particular post, the source of recruitment should be from candidates with TTC qualification
or B.Ed qualification is a matter of recruitment policy. Please mark the word policy. We find sufficient logic and justification in the state prescribing qualification for the post of primary teacher as only TTC and not B.Ed. Whether B.Ed qualification can also be prescribed for primary teacher is a question to be considered by the authorities concerned, but we cannot consider B.Ed for the present vacancies advertised as eligible. I am very heavily relying on the last 10 lines of this paragraph. What your lordship said was whether a particular, just above classical C, whether for a particular post, the source of recruitment should be from candidates with DTC qualification or B.Ed is a matter of recruitment policy. So it is a policy matter. Number two, we find sufficient logic and justification in the state prescribing qualification for the post of primary teacher as only TTC, not B.Ed. Good enough. They say we find logic, it could be done. But whether B.Ed can also be prescribed is a question to be considered by the authorities concerned. We cannot for the present consider them to be eligible. Having said so, what ultimately the court does in para 16, the all appointments of B.Ed are not disturbed. Only they are disturbed to the extent necessary to accommodate the writ petition.
That may not be relevant.
Yes,
Because
yes.
the relief ultimately is granted in so many factors.
So, my lord, I would respectfully submit in rejoinder that the debate before your lordships has been considerably widened to an extent which is not even necessary for the purpose of deciding these appeals. According to me, the focus is two issues were addressed by Dr. Singhvi, and those two issues are actually the crux of the matter. He first said that there is no power to issue such a direction with the central government under section 23(1) read with 35. I have to meet that point. That's according to, as I understood, that was his first argument. His second argument was NCT has not applied its mind.
Under 35 directions can be issued only to the government.
I'm going to answer it. I have to answer that. I'm going to answer. So he first said that there is no power to issue such a direction with the central government under 23(1) read with 35. So let me answer that, and let me tell your lordships what simply this is shutting your eye to half the statute available. There are two statutes which have to be read in harmony with each other. What is 23(1)? 23(1) of the 2009 Act, and I already showed from the statement of objects and reasons, scope of 2009 Act and scope of 73 Act. 23(1) of the 2009 Act says, any person possessing such minimum qualification as laid down by an academic authority authorized by the central government by notification shall be eligible. No regulation is required under this Act. You don't need NCT to make a regulation for the purpose of this Act. Anyway, the regulation argument is answered in my favor by the Rajasthan High Court in para 42-43, and there is no appeal against that part of the judgment. I'll go to that a little later. So now let us interpret 23. So what does 23 say? Any person possessing minimal qualification as laid down by an academic authority. Now the academic authority could have been UGC, academic authority could have been AICTE, academic authority is NCT. Now how that academic authority is to exercise its powers will not come under this Act. It will necessarily be regulated by the Act under which the academic authority is constituted. So to say that the 29 of NCT Act will not apply is completely erroneous in law is my respectful submission. That is the pleaded stand of NCT in its special leave petition.
But only
Yes.
corollary submission was made by Ms. Arora that even if NCT, we accept that NCT has an application in 23(1), the manner in which minimum qualification
I will come to that.
is laid down.
I'll come to that. She says regulation. I'll come to
Yes.
She says regulation. I'll come to that. I'm conscious of that.
Then 29(1), material provision has been read in Bombay Port Act, whatever it is.
I'll tell your lordship. I'll tell your lordship what Bombay Port Trust judgment is. Bombay Port Trust had regulations. Those regulations said degree holders are 2024, your lordships hold, and in the face of the regulation, such a directive could not be issued. Please have that judgment immediately, those two paras only. Then your lordship sees it at your lordship's leisure before your lordship finally takes a view. Just this is that judgment. If there had been no notification adding BEd in the 2010 notification, and the government had issued a directive to NCTE to make BEd people eligible, and NCTE had said yes, they are eligible by an executive order without notifying it, then the port trust judgment would apply. I hope I am clear in the distinction I am making. There are no,
Are you trying to say because in Bombay Trust case there was nothing like 23(1)?
no. In Bombay Trust case, the basic regulation prescribing the qualification had not been amended. Without amending the regulation prescribing the qualification, a directive had been issued to make diploma holder eligible. Under the Bombay judgment, only degree holders were eligible under the statutory regulations for just take that judgment for 1 minute. Yeah, because we will have to read the judgment in 568 in volume 3 of the compilation. Just have that judgment.
Yes.
Just have, kindly take up para 5.
Page 571.
Actually, I'll read from para 3 because regulations are quoted in para 3 and 4. The Madras Port Trust employees appointment promotion regulations were made under section 28 of the 1963 Act. May I pause here, my lord? If I can just explain to your lordships.
568. No. 570.
Shall I just, in my own words, again say what I am trying to say and then read the judgment?
Follow what you're trying to say. You are saying that the basic minimum regulation was not, qualification was not amended.
Correct.
Something else was not.
A directive was issued to make a diploma holder eligible without amending the regulation. So, to apply that analogy to the facts of our case, the 2010 notification lays down ETT, diploma, etc. eligible, BEd eligible for 2 years that under the relaxation clause. If without notifying a fresh notification as has been done in 14, a directive had been issued under 29 to include to make BEd eligible, then this judgment would have come to their aid. But here the difference is that directive is issued to the authority competent to make the regulation, NCT, and NCT has amended the regulation. So so therefore this judgment will not apply. The other argument that NCT has not applied its independent mind can be a separate issue which I will deal with. I hope I've made.
You're saying that in this case,
Correct.
the amendment, the direction was given straight away under the provision given in the residuary clause.
Correct. Without corresponding amending the regulation. The regulation still.
Without there being a notification in 23(1).
Correct.
In this case,
Correct. In this case, the directive went to the body competent to amend those, make that notification, and the body has made issued the notification.
they followed the procedure.
Correct. So the only argument which possibly can be is they have not applied their mind.
No, but then this whole argument is dented to the extent that the counsel for NCT is saying we have done nothing. We got the order.
I will meet that. I have to meet that. That's the second point that Dr. Singhvi made, and I have to meet it. I'm still on the first point. I will meet it, and there is, according to me, there is no merit in that submission. And I'll tell your lordship why when I come to it. Now, so therefore, just see now para 3 and 4, what this position is. The Madras Port Trust Employees Appointment Promotion Regulations 1977 were made under section 28 of the 1963 Act. 28 of 63 Act gives power to make regulation. Regulation is made. Same Act gives power to issue directive and policy. So the directive can't override a regulation. It's very simple. The
Regulation 5 read with the schedule provides that so far as appointment to the post of executive engineer is concerned, possession of a degree in civil engineering is imperative, and the direction was make diploma holder eligible. It was amended with the approval of the central government in terms of subsection 1 of 63 Act. Regulations have statutory force. They have been published in the Gazette. Not only approval of the central government was obtained, they also laid before both houses of parliament. Some of the employees were diploma holders. They formed an association known as Chennai Port Trust Diploma Holders Association. In view of the embargo placed by the regulations on their promotional prospects as the educational qualification for executive engineer, they made a representation.
So you got your point.
So writ petition was filed, etc. Then directive was issued. Now just see this one paragraph, which really gives the crux of it. Just kindly see para 21, which is the crux of the whole matter.
The statutory
Have not been amended. That's the whole point. So you can't issue a directive on a matter of policy which goes against the regulation. So this judgment cannot come to the rescue. This would have been a good judgment to rely on if there was no notification under 23(1) notifying the qualification. Says statutory regulations have not been amended. The central government, as noticed, does not have any power in regard thereto. Under the 63 Act, all regular authorities specified are statutory. They have to act within the four corners. The legal principle that administrative act must yield to a statute is no longer res integra. So it is an administrative direction. It has to yield to a statute. Now this is regarding this judgment. Now we are coming back to 23. Now 23, so my argument on 23, Lord, I need not labor and elaborate it too much. My argument on 23 is, just kindly see 23 with me once.
23, what you indicated just now, that NCT enters this 23(1) with all its trappings under.
Correct. Central government has authorized NCT. Once central government has authorized NCT, exercise of powers by NCT will have to be regulated by that act. This act doesn't tell us how NCT's powers are to be regulated. And tomorrow, central government can say UGC is the competent authority, hypothetically. Then we have to go to that act to see how UGC has to act. So, when the authority is given to NCT, how does NCT have to prescribe qualification? It has to prescribe it by a notification. If NCT makes a regulation under the NCT Act, it is of no help under this Act. Under this Act, it has to be a notification. So therefore, the whole argument of how regulation under that Act is framed is completely irrelevant in my respectful submission. Because 23(1) says, academic authority empowered by a notification has to prescribe qualification. Academic authority empowered has by notification prescribed qualification. And there is absolutely nothing wrong in it. Now, just kindly have this 2014 circular and 2 paragraphs of the High Court judgment. The 2014 notification says, what is the qualification? Qualification is as laid down in this August 10 notification as amended from time to time. This has been amended, and that is precisely what the High Court records in para 42-43. Just kindly have these 2 paras of the High Court judgment. And they are not in challenge. They have not raised a challenge to that. How can they argue this in this court without challenging those findings?
We should also get the.
So, just kindly see that notification. Yes, I should go a little.
Sir, those observations are in your favor.
Correct. This point is dealt with. Kindly have para 42-43. Just see para 43 straight away. Para 43. The learned counsel, Shri Vigyan Shah, was perhaps not correct in contending that NCTE could not have amended the eligibility criteria without amending the notification dated 12th April 14. This is the argument raised now. Under this notification, clause 4,
What they mean is without amending the regulation.
correct.
Notification regulation.
They say that
Without amending the regulation.
they say that is not, this is also not a regulation actually. If your lordship will see this, this is also a notification. But they say this was placed before the parliament. So therefore they say,
In terms of 32 and 33.
so they say we will elevate it to the status of a regulation. I don't think that can be done. It after all remains a notification. Whether it has been placed before the parliament or not, it's not a regulation. And even this can be amended by the NCT in the exercise of powers under 23(1). Because, but let us see in any case what the, so just kindly see this notification. I mean, this notification actually, just see para 3.
Just a minute. What else is regulation? Because regulations are framed under 32. Power to make regulation and give it, the powers are given to NCT.
Those are not separately done. That's not a notification then. Then those are drafted separately, those are framed separately, and I'll just take your lordship.
How else will the regulation be framed? NCT has framed the regulation, that is not in doubt.
Correct.
When NCT has to frame regulation under 32, 33, these regulations have to be placed before both the houses.
Correct.
So there's nothing wrong.
The council may, by notification in the official gazette, make regulations not inconsistent with the provisions of the Act, and the regulations made thereunder generally to carry out the provision of this Act. So that regulation will be quite different from a notification. A regulation then will have to necessarily follow the procedure of being laid before the parliament, etc.
That has been done.
In 14 it has been done. In all earlier or later notifications,
Earlier there was no requirement because there was no 12A.
correct.
There was no requirement. So our argument is that after 12A, it has to be done by regulation.
No, 12A here will not apply because 12A gives power to frame the educational qualifications by regulations. But when we are coming to the 2009 Act, the 9 Act says it is to be done by notification. Regulation is not required. Please see the 9 Act. We are ultimately, this notification now is being issued under 23(1) of the 2009 Act.
If your argument is
Then it is
NCT enters 23(1) with all the paraphernalia of NCT Act,
then
then this becomes applicable.
Correct. So even if this doesn't change anything, because the regulation itself says what will be the qualification. Qualification will be what is prescribed in the 2010 notification as amended from time to time.
Change the by notification.
Please read serial number 3 with me.
See, what we are wondering, this regulation, notification of 12th November 2014, a minimum qualification has been prescribed.
Correct.
Now, in the event it is altered by a notification not following this channel, then that podcast judgment will become applicable against you.
No, this regulation itself says what is to be done. Please read it. The regulation gives the power. And that has been discussed by the High Court and in Moria also, both.
Okay, well,
Just read first schedule, serial number 3.
yes.
Minimum just the title of the schedule. Level, minimum academic and professional qualification. Your Lordship got that one right at the top. Now for preschool it is given, preschool nursery it is given. Now primary and upper primary, classes 1 to 8. Minimum qualification as laid down by National Council for Teacher Education, vide its notification dated 23rd August 2010, as amended from time to time, issued in the exercise of powers conferred under 23(1) of the RTE Act. So this regulation itself has authorized NCTE to lay down the qualification by notification under the RTE Act.
Now let us read what has been the Rajasthan High Court on this.
Yes, this is precisely what the High Court says. That the regulation itself empowers it. Yes. Para 43. The Learned Council, my lords about it. The Learned Council, Shri Vigyan Shah, was what happened?
Yes.
My lord, this is both.
You carry on that.
It's a little important.
161.
Put him after.
Yes.
Yes.
The Learned Council, Shri Vigyan Shah, was perhaps not correct in contending that NCTE could not have amended the eligibility criteria without amending the notification dated 12th November 2014. Under this notification, Clause 4 provides for qualification for recruitment as provided in the schedule. The first schedule pertains to minimum academic and professional qualification at different level of schools. Clause 3 contained in the schedule pertains to primary and upper primary, class 1 to 8, and the qualification prescribed are minimum qualification as laid down by the National Council for Teacher Education, vide its notification dated 23rd August 2010, as amended from time to time in exercise of powers conferred by subsection 1 of section 23 of the Right to Free and Compulsory Education Act 2009. As per these regulations, thus, the essential qualification for appointment are those as prescribed under the notification under subsection 1 of section 23 of the Act, namely one dated 23/8/10 as amended from time to time. Thus, the moment the notification dated 23/8 is amended by NCTE in exercise of powers under subsection 1 of section 23, automatically such change gets reflected and embedded in the qualification prescribed in the first schedule of these regulations. Thereafter, there was no need to amend this notification. All challenges to the preliminary notification would automatically be all changes. It should be changes or maybe challenges to in the preliminary notification would automatically be recognized for the purpose of the said schedule. Now, this exact point was also raised in Ram Sharan Maurya. And in para 76 of Ram Sharan Maurya, just read that one para with me here. It says exactly the same. Volume. No, it's in IA 25803, para 76. Page. They have it. They have it. Page 48 of this. Para 76. There it is. Going.
Yes, yes.
Going by the parliamentary intent in empowering NCTE under the provisions of the NCTE Act and specific authorization in favor of NCTE under the said notification dated 31st of March 10, the authority of NCTE is beyond any doubt. Though there is no specific regulation as contemplated under section 32 read with 12 and 12A of the Act for the present purpose, by virtue of specific authorization under the entitled to lay down those holding qualification of Bachelor of Education as entitled in said notification are entitled to be appointed as teachers for classes 1 and 6. Such prescription on part of NCT would be binding. It is for this reason that the GO dated 1st December 18 notifying ART clearly stated that candidates possessing minimum qualifications specified, including one of 18, were entitled to participate in ARTE 19. And in fact, not only this PF, there have been various changes made, some relaxations done. They are all under notifications. There is no regulation framed by NCTE so far as the RTE Act is concerned for appointment in primary schools. So therefore, the clear under section 29, the moment NCTE is appointed as the authority to lay down the qualification, its powers will have